Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 143. As we will all be aware, non-disclosure clauses are very much in the news at the moment. I will come in a moment to exactly why that is, but I think there is little doubt that the topic is a pretty high-profile one for employers and employees and employment lawyers. So I wanted to spend a podcast episode just talking about non-disclosure clauses in employment contracts and settlement agreements. As always, you can access the podcast via iTunes or on the Mayor Brown website or YouTube and the Twitter feed, Nicholas Robertson at Nicholas ROBER11. And that's where we post out links, as I have said. Oh, whilst we're doing admin, please don't forget the special guest podcast we did with David Reed QC last week, which came out on privacy. It's on privacy in employment tribunals, and we thought it was a great idea to have David come in and talk about privacy issues in employment tribunals. Can you keep sensitive confidential documents out? What about difficult matters relating to embarrassing or personal fact patterns in a case, sexual misconduct allegations, for example? What can the tribunal keep in and out of the public domain? Do have a listen. David, as always, is an excellent guest. Right, we're back to NDAs. Let's talk about terminology. Let's deal with that to start with. These sort of clauses and articles written about them are referred to them as NDAs, non-disclosure agreements. But in practice, in my experience, it's relatively unusual to have something which is a specific agreement just dealing with non-disclosure. It's far more likely that these are clauses within other agreements which have the impact of restricting disclosure. I do think it's important, however, we recognise we're not just dealing with specific non-disclosure agreements. We're looking at clauses which have the intent or effect of preventing or prohibiting or restricting disclosure. So when I refer to NDAs, please understand them as you could have an NDA clause as well as an NDA agreement. Clearly, the concern with NDAs is that they can be used to gag victims of unlawful action very effectively. If you put the right clause in a contract of employment or a settlement agreement or something similar, the argument runs, you can prevent individuals making any disclosure. In that way, it's argued, serial harassers can get away with paying off victims and gagging them at the same time from reporting their concerns, so the harasser, it is alleged, is free to strike again. So the first point is to look at situations where NDAs, or NDA clauses perhaps more accurately, can be found. Obviously, we will all be familiar that NDAs can be found in settlement agreements. Secondly, there are going to be clauses in employment contracts which may have the effect of restricting an individual's ability to report wrongdoing to appropriate authorities or to the police. For example, think of confidentiality clauses in contracts of employment. The same would apply in a consultancy agreement. I think it's relatively unusual to have an NDA document as a standalone document, but I have heard of cases, perhaps in the entertainment world, with very high-profile individuals, where employees, who are going to do some work with that high-profile individual, perhaps around their home, for example, have to sign non-disclosure clauses about not revealing anything they see. Actually, having done a first draft of this podcast last week, I was out for lunch on Sunday with someone who told me they'd ended up on a Christmas TV show and had to sign a non-disclosure agreement before they were allowed to take part. So maybe these things are more common than I realised, or maybe I just don't move in the right circles. Certainly no one's asked me to appear on a Christmas show. May have to put my own one on at this rate. Anyway, I said I'd talk a little bit about why NDAs in an employment context are so much in the spotlight. Obviously, part of this goes back to the Harvey Weinstein saga, which is, of course, continuing. It was said there were a number of complaints and cases against him which were settled. It seems these clauses had these agreements had NDA clauses in them. The most notorious from an English law perspective is the one which applied to Zelda Perkins. I've not seen the document itself, although it may be potentially available online. The suggestion is that it was 8 pages of extensive restrictions on disclosure. She was unable, for example, to tell her doctor what had happened. Family members could only be told if they signed a similar agreement. She was not permitted to retain a copy of the agreement. Whatever the circumstances, it was definitely an extreme version of a normal NDA clause in a settlement agreement. However, the combined effect of the publicity around that and the allegations fueling the rise of the #MeToo movement mean that there have been a number of official reviews of NDAs in the employment sector in the UK in the last 12 months. We've had an SRA warning notice to solicitors sent out in March. There's an EHRC report, the Women and Equalities Committee in the House of Commons report, and so on. Indeed, they've just announced a new inquiry into NDAs in harassment and discrimination cases. The government has announced it's looking at proposals in this area too. So, NDAs are finished, right? No, wrong. If you look in a bit more detail at what some of the reviews have said, it's all quite revealing. Let's start with the Women and Equality Select Committee report from earlier this year. The report makes a number of comments. They say that the Government's Equalities Office had confirmed to the committee that in the Equalities Office view, NDAs form a legitimate part of an employment contract. The committee report acknowledges this, but says they are concerned about them being used unethically by some employers. In an aside, and this isn't referenced directly in the report, there is of course a suggestion the waitresses who were working at that infamous President's Club event had to sign advance NDAs, so they may have a case in point here. Secondly, the Women and Equalities report acknowledges that there is a place for NDAs in settlement agreements. They say they have grave concerns, quote-unquote, about unethical use, and they say that the law on protected disclosure is unclear. Obviously, in theory, an attempt by an employer through a contractual route to prevent someone exercising the statutory rights below the whistle through appropriate means to an appropriate regulator is unenforceable. But I do think it's fair for the committee to make the point that the statutory test for what is or isn't appropriate disclosure, is it sufficient in the public interest to qualify, etc., etc., do make it a fair comment that the law on protected disclosure is unclear. Confidentiality clauses included in documents may be unclear too, and they may effectively function as NDAs, the committee went on to say. They record the fact in the committee report that the SRA told the committee that in 2016 a solicitor was disciplined for including in a compromise agreement a clause restricting the reporting of misbehaviour to a regulator. It's not clear, I should say, whether that is a solicitor acting in relation to a complaint within their own business, or whether that was on advising a client, and but the solicitor got disciplined for the advice given to a third party. I'll come back to that. At the end of the day, the report says that the government should come up with an approved standard set of confidentiality clauses to deal with the concerns that confidentiality clauses could operate as informal gagging clauses. They would like the definition of protected disclosures and in the whistleblowing legislation to include a clear approval for disclosure of sexual harassment to the police and any regulator. They also want the government to make it an offence for an employer or a professional advisor to propose a confidentiality clause designed and intended to prevent or limit protected disclosures or criminal offences. It should be a professionally disciplinable offence for confidentiality agreements to include potentially unenforceable clauses. The SRA, as I say, sent out a warning notice to solicitors in March 2018. And it's crucial to appreciate this applies to solicitors in England and Wales, both in relation to their own business and when they are representing clients. These are duties that apply to lawyers personally and when representing clients. The SRA warning notice starts by picking up on the widespread perception that NDAs result in low levels of reporting of inappropriate sexual behaviours. They expressly recognise that NDAs can be appropriate to protect commercial interests, confidentiality and reputation. The SRA notice goes on to say that whilst NDAs are not prohibited, they must not leave an individual feeling unable to notify the SRA or other regulator or law enforcement authorities about alleged wrongdoing. The law firms themselves, if it's a matter within the law firm, must also remember to notify the SRA of any alleged conduct. Finally, according to the warning notice, it is inappropriate to use NDAs to improperly threaten litigation or to threaten adverse consequences to get people not to make protected disclosures, or to report to the regulator or authority or enforcement authorities concerns about wrongdoing. The warning notice says that if solicitors fail to take this on board, they are potentially in breach of the SRA principles, which are of course crucial. In short, they said that NDAs are inappropriate if they prevent or deter someone from reporting misconduct, making protected disclosure, reporting an offence to a law enforcement authority, or cooperating in a criminal investigation. Well, thinking therefore about confidentiality clauses, it's quite easy to see that a confidentiality clause might be thought to deter people from assisting in an investigation. The SRA notice goes on to say that the NDA must not influence the substance of any report or cooperation, and must not prevent someone who's entered into an NDA from keeping it or receiving a copy of that NDA. I think it's extraordinary, and I've never come across any suggestion that removing a copy from an individual would work. It seems to be a bit impractical. How is the individual supposed to know what they can or cannot do if they haven't got a copy of the agreement? Anyway, the SRA notice puts paid to that. The SRA also say that the person expected to agree the NDA must not, quote, be given the impression, unquote, that disclosure is prohibited, always. Otherwise it must be made very clear where disclosure is permitted. I think, therefore, that simply cross-referring to a statutory section in light of the SRA notice would be potentially giving the impression that more was prohibited from being disclosed than was truly the case. The SRA say that if the individual is not represented, then the obligation on the solicitor is heightened to make sure that the true position is absolutely clear. Again, obviously, if we have settlement agreements, the individual will always have taken independent legal advice. However, think about contracts of employment and confidentiality clauses. There is, of course, it is much less likely the individual will have legal representation. Finally, the SRA say that the NDA must not include clauses known to be unenforceable. So clearly you can't put in a blanket NDA into a settlement agreement and then say you had no intention of enforcing it. The Equality and Human Rights Commission report on ending sexual harassment at work was also produced in March 2018. It has a section dealing with NDAs, although of course the report goes much wider. In the relevant section, they say they want the government to legislate to provide a clause which prevents disclosure of future acts of discrimination, harassment or victimisation. They would want to see that clause made void. They want a statutory code of practice on sexual harassment which would set out circumstances in which confidentiality clauses would be void. They say that the best practice with NDAs is to pay employees legal costs enough to receive independent legal advice to include the reasonable costs of agreeing changes to terms. Employees should be given a reasonable time to consider settlement, to allow the employee to be accompanied by a trade union representative or colleague when discussing the settlement agreement. Confidentiality clauses should only be used at the employee's request, they say, save in exceptional circumstances. They want an annex to be put in any settlement agreement explaining why the confidentiality clauses are being included, what their effect is, and they go on to say that non-disclosure agreements at the start of employment relationships should never be used. I think by a margin this is the most extreme of the views, perhaps unsurprisingly given the context in which the report is being written. Obviously, in settlement agreements a number of these things already happen, given that individuals have the right to independent legal advice in order for the settlement agreement to be valid and enforceable. However, I think if we ever did get to a situation where confidentiality clauses could only be inserted at the employee's request, many more cases would fight to a conclusion. I also think that the non-disclosure agreements, non-disclosure clauses at the start of the employment relationship are very rare, but as I mentioned, I think there can be a place for them. Obviously, they shouldn't gag any wrongdoing, prevent any wrongdoing being disclosed appropriately. Then we have the ABC case, which I dealt with in a previous podcast in some detail, and so I'll only deal with it briefly. The question for the Court of Appeal in that case is whether an employer and senior executive could get an injunction to prevent the Daily Telegraph from publishing information obtained apparently in breach of certain NDAs. The NDAs had been included in settlement agreements where apparently 5 employees had made separate allegations about inappropriate behaviour by a senior executive. Each of the employees signed settlement agreements containing NDAs and where both parties agreed to keep the subject matter and the complaints confidential. There was an exclusion for the right for the individuals to make legitimate disclosures, including reporting any criminal offences. The individuals had, of course, obtained legal advice before entering their settlement agreements. The Court of Appeal, if you remember, granted the injunction and said that provided the NDA was freely entered into without improper pressure, and with the benefit, where appropriate, of independent legal advice, and with due allowance for disclosure or wrongdoing to the police, then the regulatory body, then there were public policy reasons in favour of upholding express contractual obligations of confidentiality. These could well outweigh the right to freedom of expression of the party that wishes to publish that information. The Court of Appeal was, I think it's fair to say, fairly pro-NDAs, saying they played an important part in the consensual settlement of disputes, and the employees themselves may wish to maintain confidentiality in relation to the settlement of the dispute with the employer. It was noticeable, in this case, I think, that 3 of the 5 employees expressly said they wanted the injunction to be continued, so they were on the side of the employer. So, where does that leave us? Well, first of all, I think there's a myth abroad that says NDAs are somehow objectionable or immoral per se, and parties should not rely on NDAs. We've certainly had employee advisors try and assert that to us. I think this is simply not the case. None of the bodies that have looked at NDAs have gone anything close to saying NDAs should be prohibited. The Government Equalities Office, the Women and Equalities Committee and the SRA all recognise a role for NDAs. Equally, however, I think employers and lawyers are going to have to look closely at contracts of employment and settlement documents to ensure that nothing is said in those documents that might be thought to inhibit a party from disclosing wrongdoing, etc., to the appropriate parties. I gave one example earlier on. I think if you simply cross-refer to the relevant section of permitted whistleblowing disclosures, that would not be enough. That would assume that the employee's independent legal advice, which is usually not the case when entering the contract of employment. They just don't have that, have taken independent legal advice. Probably then means that the contract needs to be super clear. But we think in the contract of employment and the settlement agreement it's going to be important that there is a suitably explicit clause saying that nothing in the settlement agreement prevents the individual from cooperating with criminal investigation or from making any report or disclosure to any law enforcement or regulatory authority, including the police, or where otherwise required by law. I think it's probably also important to have some sort of reference in there to protected disclosure. I think the contract of employment needs to say something similar in it too. The other thing that we're looking at the moment is adding something to the signature clause for settlement agreements for the individual, to say perhaps that his or her legal advisor has advised them that the settlement agreement does not prevent them from making any report or disclosure to the appropriate authorities. I'd be really interested if anyone listening to the podcast has any views on this. I think that NDAs are in principle unobjectionable provided they have the appropriate carve-outs. But equally, if you're acting for employers, you're going to want to ensure that those carve-outs are in the settlement agreement, probably in order to maintain your professional standards. So I'd be really interested if anyone else, as I say, is making changes to their documents or to their practice. Do get in touch, do let me know. But in the meantime, I thought flagging up those potential changes and amending up confidentiality clauses and your settlement precedents, I hope that would be useful. Next week, or shortly after it, we'll be back with the normal 3-case podcast. So thank you very much for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.